The sixth important concept or principle of constitutions is known as separation of powers. Let us see what it means. It is a doctrine which is derived from John Locke and Montesquieu. The idea is behind this principle is that power should not be concentrated but separated. This means this principle emphasizes that political power or legal power should not be in the hands of the same person. Rather, it should be distributed to various to various organs or persons in principle. There are of course separation of power traditionally, which are distributed to the legislature, that means the lawmaker, to the executive, which implements the law, the government organ, which implements and then controls the implementation of the laws, and the third organ, as you know, the judiciary. So power is basically traditionally distributed between these important government organs. However, separation of power involves even more things. That it recommends that separation of power does not mean insulation of different organs which exercise such powers. Rather, that it prohibits interference or control of one organ of the other inappropriately. Therefore, a complete separation is not wise or is not recommended. Rather, there should be an exercise of power by different persons in order to avoid that concentration of power in the same organ, and thereby allow that organ to exercise arbitrary power. For instance, in the United States of America, this principle is implemented in an exemplary manner, that power is divided or separated and given to various organs, that each organ exercises around the power which is given to it, and thereby has also got a horizontal relationship. Each organ will have a horizontal relationship that does not affect the exercise of power of each. The next important concept or principle of constitution is known as judicial review. Let us see what it involves and what it means. Judicial power involves the idea that a court's power to declare a statute is given to the court, and any unconstitutional act shall be, or the court has the power to revise any unconstitutional decision and to interpret it on the basis of the laws given to in relation to that act. This, in other words, or as in the example, we can see that any kind of decision of court, any kind of law made by the lawmaker or by the legislature, or any kind of administrative decision, or any kind of decision given by relevant authorities should be in line with the Constitution. If there is any act which is contrary to the Constitution by any authorized body, it can be declared as an illegal one, or it can be interpreted by the court, by the judicial power, to be unconstitutional, and this is also provided in the Constitution of the FDRE. So such an appeal from an administrative agency's decision can be revised by the court. The court can revise any decision given on the basis of a given law and decide whether it is constitutional or not. Then if it is found to be unconstitutional, it will of course be repealed. This also involves a higher court's examination of lower court's decision. That means a decision by a lower court can be revised by a higher court and examined, and if it is proved to have been inconsistent with the Constitution, then it can automatically be repealed. As I have already said, courts take control of also decisions taken by administrative and other decision-making bodies, and this is of course expressed in the revision or in the power to revise these decisions by courts and decide whether the decisions are consistent with constitutional provisions or principles, and thereby if found unconstitutional, they will be cancelled out. So this is the most important idea of the concept of judicial review. So other principle or other important concept which is related to constitutions is the concept of constitutionalism and democracy. Let us see the diversity and unity between these ideas or principles. As we have already mentioned earlier, constitution is expressed as legal and moral framework setting out of legislative, executive and judiciary parts of government and their limitations. As we have already said, constitution determines the powers and duties and responsibilities given to each government body, which legislative, executive and judiciary, and also determines the relationship between each other. So this is an important characteristics as already mentioned. So this framework which is put in place in the constitutions must represent the will of the people. It must happen through consensus, and all other laws within a country must abide by and follow the principles of the constitution. So these ideas are raised to show what actually constitutionalism means. Going further, let us see what important elements the concept constitutionalism involves or incorporates. It is an ideology of following the constitution by the word regardless of what it says and supports it. So this approach or this view of the constitutionalism involves the idea that any government power, any government organ should exercise its power according to the provisions of the constitution, regardless of the provisions content or the provision to be correct or not in the sense or in the understanding of the implementer. This idea, of course, aims at limiting the government's power. So it is expressed that constitutionalism is an idea of limited government as a result of putting the law above the government, or taking the idea of supremacy of the law. It insists that government should act only according to the law which is provided to its duties and responsibilities and powers. Government should not be above the law, and government should always be bound by the law. This concept of constitutionalism is primarily based on the notion of people's sovereignty, which is to be exercised in a limited manner by a representative government. So here you can see that both democracy and constitutionalism are in favor of the sovereignty of the people, but the difference lies thereby that the constitutionalism insists on the limitation on the exercise of power by government in a limited manner through their representatives of the government. It says not all states with constitutions, of course, will have embraced constitutionalism. Sometimes this indicates that there are governments which have put in place various provisions in their constitutions, but do not act accordingly. Let us see further what constitutionalism involves. It is the idea that government should be limited in its power and that its authority depends on its observation of these limitations. So this statement summarizes what has already been discussed, that what constitutionalism involves or what its elements are can be seen in this statement, that number one, government's power should be limited, and that authority of government always depends by observing the limitations which are of the power of the government, which are put by law or which are expressed in the law. On the contrary, authoritarian governments or military dictatorships do not fulfill the tenets of the supremacy of the law or the separation of powers. That is why they are labeled as authoritarian governments, that even though sometimes you can find dictatorial governments whereby they don't have any constitutions, or even though they have constitutions, those tenets or basic principles of the constitution, including constitutionalism, are not put in place or they are not implemented. You can see as an example that in Cambodia they had a government which is absolutely authoritarian, which does not take care of the provisions of the constitution, but acts authoritatively and acts arbitrarily, and it can be a good example of an authoritarian government. Therefore, it is not the constitution that reigns supreme in such governments, but those in power. That means the rule of law is also violated, the principle of rule of law, which requires that law should be above the government, and government should be bound by the laws that it is self-made. And in the case of the Cambodia, this is not true. It doesn't hold true. On the contrary, the power is given to the government, where it should have to be exercised or it should have to be controlled by the laws, as it is explained in the principle. To have more idea, more clarity on constitutionalism, you can see that what elements or what important ideas or basic ideas constitutionalism involves. It distinguishes between adopting a constitution and genuine constitutionalism, as I have already mentioned earlier. Example of Cambodia, in the earlier periods, there was a constitution, but it is not observed. A constitution is not merely a document introduced by the state with the title of constitution, even though there is a document which is identified or put in place or introduced as a constitution, but it must be observed, it must be obeyed. What is this constitution? This is the idea what constitutionalism requires. For instance, many authoritarian regimes introduce such documents to justify arbitrary rule. They put in place documents which are known as constitution, but they will not practice what is provided in their constitutions. Therefore, that is why they are recognized, or they are identified as authoritarian regimes. That means authority is given, the law is not respected, the law is not observed, rather what they wish is put in place. For example, in Thailand, such things or such events have been manifested. Genuine constitution, on the contrary, is an attempt to limit and reverse all forms of arbitrariness, as we discussed in the earlier lecture, that genuine constitution should be observed. It is recommended that government should act according to the law. Its powers should be limited so that arbitrary decision will not be practiced, and arbitrariness be avoided in such respect. That is what constitutionalism recommends. Another idea which is very fundamental in constitutions, and which is a little bit different from that of constitutionalism, is the idea of democracy. As you know, the idea of democracy is a form of government that relies on the majority vote of the population. Having this in mind, democracy can be expressed in direct and representative forms. Direct democracy is whereby political power will be exercised by one who is directly elected by the whole people in a given state, whereas representative form of government involves parliaments and also representative or members of that parliament, which are elected by the people to represent the people, which is different from that of the direct democracy, where power is given to, for instance, a president, which is directly elected to the people, having more power than that of the parliament itself. On the contrary, representative forms of government involve parliaments having more power than that of the prime minister, or etc. Let us see the contrast and comparison between democracy and constitutionalism. Democratic government consisting of multiple political parties. That means what democracy is constitutes. What constitutes democracy is that it consists multiple political parties. There is fair elections, or there are fair elections. It involves freedom of opinion and expression. The rule of law is put in place, or it is a guiding principle of the democracy. So when we talk of constitutionalism and constitutions, only making constitutions will not amount to having genuine constitutions, as I have already mentioned earlier. For example, as I have said, Asian countries like India, Sri Lanka have liberal democracy. Genuine democracies rest on the sovereignty of the people, not the rules.